Tonight's courtroom breakdown starts with a brutal question that instantly changes the entire mood of the hearing. You're looking at 8 years in prison. What do you think you deserve? And trust me, once you hear everything leading up to that moment, you'll understand why this judge was losing patience fast. This case centers around Barbara Shorey, a woman already on probation for robbery, now back in court after repeatedly failing to report to probation officers. But what makes this hearing explosive isn't just the violations. It's the constant cycle of excuses, emotional appeals, and missed opportunities that keep piling up in front of the court. The prosecution says she's already had chance after chance after chance. The defense argues she's struggling with family trauma, abuse, CPS issues, and health problems. And the judge? He's trying to figure out whether this is someone genuinely fighting to rebuild her life or someone refusing to take accountability. As this hearing unfolds, you'll hear the judge repeatedly push back whenever the conversation drifts away from the core issue, probation compliance. And honestly, some of these exchanges are incredibly tense because every time the defendant tries to explain her personal hardships, the judge circles back to the same question. But why didn't you report? Then later in the video, the courtroom shifts into an entirely different case involving Brittany Cruz, where the judge takes a noticeably different tone. Instead of revoking probation and sending someone to prison, the court carefully lays out strict conditions for deferred adjudication, drug treatment, parenting classes, and supervised restrictions involving minors. It becomes a fascinating contrast between two defendants standing at completely different crossroads in the justice system. One woman is watching probation collapse in real time. The other is being given a final opportunity before things spiral out of control. And throughout both cases, the court keeps returning to one major theme: communication, accountability, and whether people are truly willing to change before the system finally runs out of patience. So as you watch this hearing unfold, ask yourself this: how many chances should someone get before probation is revoked? And when personal trauma enters the courtroom, how much should that affect sentencing decisions? Because by the end of this hearing, the judge makes it very clear where he stands.
Question for you is, you are looking at 8 years in prison. The state wants you to do the full 8, which is a part of your contract. Your defense attorney wants you to do 2. My question is, what do you think you deserve? The court is calling 2017 CR 9939, State of Texas versus Barbara Shorey. Could I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
David Blair.
And are you Miss Shorey? I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Okay, you're going to need to speak up, okay?
Yes, sir.
Are you the same Barbara Shorey who was placed on community supervision in 2017 CR 9939 for the offense of robbery on June 21st, 2018 for a term of 6 years? Is that you?
Yes, sir.
State?
Condition number 5, in Bexar County, Texas, the defendant Barbara Shorey did then and there fail to report to the supervision officer as directed for the months of July and August of 2021 in violation of condition number 5.
How do you plead to that, true or not true? I'm sorry?
True.
State?
Judge, we'll waive the others.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 5, the court can find it true, grant the motion, sentence you to 8 years in prison and up to a $1,500 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court is finding violation of condition number 5 true. Is there an agreement?
There is not, Judge.
All right, state, what are you requesting?
Judge, we are asking for revocation. This appears to be at least a fourth MTR. I mean, it looks like she's pled true to number 5s at least 3 times before, so she's shown that she's not a good candidate.
Right here, you can already hear the divide between the prosecution and the defense. The state is basically saying, we've seen this movie before. According to the prosecutor, this is at least the 4th motion to revoke tied to the same issue, failing to report. That's incredibly important because probation is built almost entirely on compliance and communication. You can mess up in other areas and sometimes still recover, but when someone repeatedly disappears from supervision, courts tend to view that as a major red flag. Meanwhile, the defense is trying to frame Barbara as someone who still has a chance to turn things around through treatment and additional supervision instead of prison. But the judge's immediate response, "Why should I?" tells you everything about the courtroom atmosphere. The court isn't just evaluating excuses anymore. The court is evaluating credibility. And here's the bigger question for everyone watching. At what point does another chance stop helping someone and start enabling the same behavior? Because probation only works if the person on probation actively participates in it.
Continue probation, so we're asking that you revoke it.
Defense?
Your Honor, Barbara's just asking for another chance. I think the the probation office is recommending continue with some other conditions, and I'd like to consider that at this time.
But why should I?
You know, she has a long probation and she has children, and the probation office is recommending safety, so maybe the additional treatment will help her, get on the right track.
All right, Ms. Shorey, is there anything you wish to say? You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name for the record.
Barbara Shorey.
All right. You want to explain to the court why you haven't been showing up? Okay, you need to lower your mask so that we can hear you.
I'm sorry, ma'am, it's because I'm quarantined for COVID right now.
Oh,
I'm
well,
under
put the mask on,
quarantine, That's all I'm saying.
but you need to speak up.
Okay. Well, this last MTR, I did report, I went to the office and they told me to leave the office because I had told the security that I had been exposed to COVID.
Well, see, here's the thing. The problem is you never show up. And when I say never, of course, I don't mean every single time, but I will tell you every motion to revoke we have for you, it's because you're not showing up.
I did show up this last time, ma'am, but they
No, you just pled true to
Yeah.
not showing up.
they asked me to leave the office and I stepped outside and I spoke with my probation officer. She asked me to go get COVID testing. And I did, and I was positive for it. And I had proof with my daughter-in-law and my granddaughter.
So did you have COVID in July? Did you have COVID in August?
Yeah.
Okay.
Yeah, well, no, I mean, July, I've had it in September, in August and September.
So you
I
didn't
went
have
to
it in
report
July.
August, I'm sorry. I got out July 28th. I was released. And then in August, I was reporting. And that's when I went to go report. And they asked me to leave the office. When I left, I called her and I spoke to her outside. I said, "Ma'am, I'm right outside your office. Can you see me, please?" She said, "I want you to go get tested for COVID." So that's what I did. I went and got tested for COVID, tried to contact
So is
her.
there documentation for that?
Well, I have documentation at home.
No.
Not-
I mean, we're here today for a
Yeah,
hearing.
She never answered my calls. She just MCR'd me.
This is where the hearing starts getting really uncomfortable for the defense because the judge begins walking through Barbara's history step by step. And notice what he's doing here. He's establishing a pattern. In court, patterns matter. One missed report might be understandable. Two raises concern, but multiple revocations tied to the exact same behavior. That tells the judge this isn't an isolated mistake anymore. Barbara keeps trying to explain the circumstances surrounding COVID exposure, family struggles, and CPS involvement, but the judge keeps bringing the conversation back to accountability. And from the court's perspective, documentation is everything. If someone claims they couldn't report because of illness, judges expect proof ready at the hearing. Showing up without records makes the explanation much harder to verify in real time. What also stands out here is the emotional collision happening in this courtroom. Barbara clearly wants the judge to understand the chaos happening in her personal life, but the judge is focused on whether she fulfilled the legal obligations attached to probation. Those are two very different conversations, and right now they are crashing into each other head-on.
Well, here's the problem. You were placed on probation on June 2018. That was before my time. But during my time, you were brought to court on March 5th, 2019 for not reporting. And so your conditions were altered and amended to include McMilef evaluations. And you had a TAP evaluation. Then we come back on May 21st, and there's a new number 5, which means you're not reporting. Then we come back on May 17th, and it was recalled for May 18th. And then it was recalled for May 21st. Then we come back on May 21st and it's not reporting. And now we're here for not reporting.
I understand. Mama. Can I speak?
Yes.
Okay, the first MTR, my mother was very sick and I had to take care of her. I went through a lot of stuff with her. The next one, I got my kids back. And, since then, like I've had two of my daughters raped and I've been going through the process of CPS, which CPS has been involved in where I've been staying with my mother and with my children and trying to get me back because I do not have rights to them because my rights were terminated. So after 10 years, their father, he abandoned them and then they were with their grandfather, which ended up molesting them and physically abusing them. And this has all been documented. And I was just trying to get
Okay, and see, that's your, and let me just tell you, you know who's the cause of that? Not of the fact that offenses were committed against them,
Yeah.
but their problem is they don't have a single parent who's watching out for them. They have a parent, which is you, who commits robberies and does not report for probation. And again,
That line from the judge was absolutely devastating. Their problem is they don't have a single parent watching out for them. At this point, the hearing stops sounding like a routine probation violation and starts sounding like the judge's broader frustration with repeated instability affecting children and families. And legally speaking, once the judge announces he's granting the state's motion to revoke, the biggest issue left isn't guilt anymore, it's punishment. Barbara has already admitted the violation by pleading true. So now the courtroom shifts into a sentencing battle. The prosecution wants all 8 years, while the defense is begging for only 2. That's an enormous gap. What's fascinating here is that the judge still pauses to ask Barbara directly what sentence she believes she deserves. Judges don't always do that, but when they do, they're often looking for one thing: insight and accountability. They want to hear whether the defendant understands the seriousness of the situation. And you can feel the tension building because everyone in that courtroom knows the next few answers could influence years of someone's life.
this is the third time I believe that we've been here for you not reporting. So I'm going to grant the state's motion. So the question is, state, how much time are you asking for?
Judge, the underline is 8, so we're asking for 8.
Defense?
We're asking for 2 at this time. Right?
All right, Miss Shorey, what should I sentence you? You're looking at 8 years. And that's what the agreement was for you to do, 8 years in prison if you didn't successfully complete probation, and you have not successfully completed it. So I'm granting the state's motion. I am going to revoke you. The only question is, how much time should I give you? So how much time do you think you deserve?
I've already had all this time taken away from my kids. So at this
Okay,
point,
they are
yeah,
children.
Yeah.
They're not kids. And number 2, the reason why you've had time away from your children is because of you. It's not because of me. It's not because of the state. It's not because of your defense attorney.
Yeah, it's just because of my past, with my my ex-husband and student being in a physical relationship, physically abused and then emotionally and mentally. Like him and his family.
What does that have to do with the fact that you're on probation for robbery? I'm sympathetic to your plight. I'm sympathetic to people who have been victims of abuse. I've had people in my family who have been victims of abuse, so I'm sympathetic to you.
I understand.
But my question for you is, you're looking at 8 years in prison. The state wants you to do the full 8, which is a part of your contract. Your defense attorney wants you to do 2. My question is, what do you think you deserve?
Barbara's response here is incredibly telling because instead of giving a number or directly arguing for leniency, she essentially puts the decision entirely in the judge's hands. And sometimes defendants do that out of fear, exhaustion, or uncertainty about what to say. But in high-stakes sentencing moments, judges often want to hear something more concrete: responsibility, reflection, or a detailed plan for change. Then the judge starts asking a series of very practical questions: restitution, anger management, completed programs, probation progress. And honestly, this is where the case really starts falling apart for the defense. Courts love documentation of progress. Completed courses, treatment records, stable employment, clean reporting history. Those are the kinds of things that help persuade a judge to reduce a sentence. Instead, the court keeps hearing about unfinished evaluations, unpaid restitution, and missed opportunities. And when the judge asks, "What have you done since you've been on probation other than not report?" that's not just sarcasm. That's the court signaling serious disappointment with the overall lack of measurable progress.
I deserve. Whatever you define me, Judge. Define me, Judge.
Okay. All right. Did she ever pay the restitution of $175 to Rosemary Mauricio probation? And did she complete any courses? Did you complete anger management?
I'm not sure if I took the class here when I was.
No.
Yeah.
Did you know if you completed anger management or not? Did you?
I'm not sure, ma'am. If I-
Probation,
if I
did she
completed
complete
what
anger management?
No, yeah.
Did you pay the $175 to Rosemary Mauricio? So let me ask you this. What have you done since you've been on probation other than not report? Have you done anything?
I was trying to get my kids situated and.
Children, they're not kids. Kids are billy goats.
For my
So-
children, yes, my children, I'm sorry.
What have you done since you've been on probation other than not report? Name me one thing that you have actually done, started or completed while you've been on probation.
From my probation.
Yes.
Honestly, it's right there, I have it.
Have you done anything?
Besides have being employed, I mean, that's all I can, that's all I can say.
Okay, so you've done nothing?
She's done a top evaluation and she did a mental health evaluation, but only the evaluation was completed.
No follow-up from her.
And then she's only paid a total of $92, 88 of which went to one of the rest.
Okay.
We have one negative drug test also.
Okay. So there is to be $87 restitution to Rose Marie Mauricio. And are you expecting or no?
No, ma'am, I'm sick from my liver, I have
Okay.
sick.
Okay. All right. They will make sure you let them know at the jail and let them know at the prison that that's an issue so that they can give you treatment for that, okay?
Yeah, I have to.
6 years, not the full 8 the prosecution wanted, but far more than the defense hoped for. And honestly, you can tell the judge tried to balance punishment with some degree of mercy here. He specifically mentions medical treatment concerns and later gives Barbara direct advice about addiction, mental health, and rebuilding her life. So even while imposing prison time, the court is still acknowledging underlying personal struggles. But this sentence also sends a strong message about probation itself. Probation is often described as an opportunity instead of incarceration, but courts expect active participation in return. Repeated non-reporting is viewed almost like disappearing from supervision entirely. And once judges believe someone is unwilling or unable to comply consistently, prison becomes far more likely. What do you think about this sentence? Was 6 years fair considering the repeated violations? Or should the judge have followed the defense recommendation and given her another reduced opportunity? This is exactly the kind of case that divides people watching courtroom hearings online.
All right, the court is going to sentence you to 6 years in the prison. Give you credit for any time served. There's to be no contact with Rosemary Mauricio
Well, he went through all that.
and her family or her residence.
If you work, it's a good story.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is, you do have a limited right to appeal. I'm sorry, could I see that again, please? You do have a limited right to appeal. And that right to appeal is as it relates to the allegations, not the fact that you're on probation. Do you understand? Right. Your attorney will explain to you the appeal process. All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, yes.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right, good luck to you. We can go off the record. Here's the thing, Ms. Shorey. It appears that you may have a drug or major alcohol problem. You cannot be in your children's lives and actively be there if you don't take care of yourself first. And that means getting your drug issues under control, taking care of your mental health issues, taking care of your medical health. Do you understand?
Now pay close attention because the courtroom atmosphere changes dramatically with the next defendant, Brittany Cruz. And this contrast is actually one of the most interesting parts of the entire video. In Barbara's case, the court was dealing with repeated probation failures after years of supervision problems. But here, the judge is dealing with someone entering a plea bargain and requesting deferred adjudication, essentially asking the court for a chance to avoid a final felony conviction if she successfully completes probation conditions. You'll also notice how methodical the judge becomes during these plea hearings. Every right is explained carefully. Jury trial rights, appeal rights, possible prison exposure, plea consequences, and conditions of supervision. That's because the court has to ensure the plea is voluntary, informed, and legally valid. And even though this hearing feels calmer than the previous one, don't mistake calm for lenient. Deferred adjudication can still become prison time if someone violates the terms later. In other words, Brittany is being handed an opportunity, but it comes with very strict expectations attached.
All right, good luck to you. Court is calling 2022 CR 10787, State of Texas versus Brittany Cruz. Can I have parties announced for the record for the state?
Debbie Cruz on behalf of the state, Your Honor.
Defense?
Somebody is not right now.
Are you Ms. Cruz? Counsel, had you received all the discovery in this case and did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. If you all could either whisper in the box and move to the other end so the court reporter will be able to hear. All right, Ms. Cruz, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand?
Yes.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Cruz, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1 gram to 4 grams as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
She has, ma'am.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Cruz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes, I am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea, the state is proceeding on the indictment as presented. There's a $1,000 fine. State recommends deferred adjudication, and there's to be restitution to the Bexar County Crime Lab for testing. Did you understand that to be the plea? Defense?
Yes.
State?
Yes.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your term of deferred adjudication be for 2 years. There be a TAP evaluation, 150 hours community service restitution, and drug education course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? To the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Doesn't,
State any evidence?
at this time, the state introduces State Exhibit 1 and all of the attachments, Your Honor.
No objection.
All right, state, you can confer.
Thank you.
All right, Ms. Cruz, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
It's her first felony offense. She's seems to be doing well. She's working part-time right now, cleaning homes. We're asking the court to grant her application.
All right, who is Sergio Huerta?
That's my ex.
Do you have any children with him?
No, no, no.
Do you have any children?
Yes, I do.
How many?
2,
Ages?
11 and 10.
Where are they?
My daughter's with my ex's sister, my ex-sister-in-law, and my son is going forward with my mom.
All right, so was Child Protective Services involved?
Yes,
And were your rights terminated?
yes.
Are those the only 2 children you have?
That was
What have you,
14.
are you living by yourself?
No, I live with my boyfriend.
Does he have any children?
Yes.
Do they live with you?
They live with me. Well, I'm staying there, so just,
I mean, do the children live with him?
yes.
And what are their ages?
18 and 2 twins are 16.
All right, any children under the age of 16?
No, ma'am.
Where, just as a side note, where is their mom?
Oh, well, they're going through a whole, that's,
Okay. When you,
Yeah.
when you're drug tested today, what are the results going to be? And you are going to get a drug test today.
yes.
What is the result?
And this,
All right, when's the last time you used?
a couple of weeks ago, I believe, but I've been.
And what did you use a couple of weeks ago?
Maybe like 3 weeks.
No, what did you use? What
This section of the hearing reveals exactly why the judge is imposing so many restrictions. Once Brittany admits recent drug use, the court immediately shifts into risk management mode. And notice how many of the judge's questions revolve around children, living arrangements, sobriety, and household stability. That's not random. The court is trying to evaluate whether minors could potentially be exposed to unsafe conditions. The restrictions that follow are extremely detailed. No unsupervised contact with minors, drug treatment requirements, sober meetings, parenting classes, field visits, employment restrictions, and intensive monitoring. Some viewers might think that sounds excessive, but from the court's perspective, this is an attempt to build a structured system before the situation escalates further. What's especially interesting is how the judge repeatedly emphasizes communication and honesty. He even says directly that he wants people on probation to succeed rather than go to prison. That's a major contrast from Barbara's hearing earlier, where the court felt repeated chances had already been exhausted.
substance?
So, methamphetamine.
Okay. All right, any other questions?
Just to
clarify, Judge, the CPS case was in 2013.
Still providing for
You pay, you give her money.
Yes, yes.
And she does send her daughter.
All right, 2 years deferred adjudication, $1,000 fine, probated. Restitution to the Bear County Lab for testing. No unsupervised contact with minors. No contact with Sergio Pablo Huerta. Drug education course. I want 90 sober meetings in 90 days. 150 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to order parenting classes because there are minors that she's in contact with. And if she ever intends to have any contact with her 11-year-old and 10-year-old, she's going to need parenting classes. Once she completes the parenting classes, the remaining of the community service hours can be waived. I'm going to want proof of employment within 30 days. There's to be no employment as a home health care provider, no employment with minors, and you are not to be employed at any location, restaurant, whose primary source of income is through the sales of alcohol. You understand? I'm going to want a TAP evaluation, and you need to be honest in the TAP. If the TAP evaluation recommends inpatient treatment, I'm going to want intensive outpatient treatment. If it recommends outpatient, supportive outpatient, I'm still going to want intensive outpatient treatment.
This may sound overwhelming, but what the judge is building here is essentially a supervision roadmap. Regular reporting, drug testing hotlines, field visits, treatment programs, parenting classes. Every condition is designed to monitor compliance closely during the early stages of probation. And honestly, the court is making one thing crystal clear. If Brittany communicates, follows treatment, and stays compliant, she has a real chance to avoid prison. But there's also a warning hidden underneath all of this. The judge literally references people sitting in the courtroom who failed probation because they stopped reporting or stopped communicating. That's almost certainly an indirect callback to the Barbara Shorey hearing we just watched earlier. The court is practically using one defendant's outcome as a cautionary example for another defendant standing right there in front of him. And that creates a powerful moment in this video because you're seeing two completely different stages of the criminal justice process unfold back to back.
There's going to be regular reporting by Zoom or in person. We're going to do the UA hotline with her, and we're going to do the UA hotline with her for at least 3 months, and we'll see how that goes. If all goes well, then she can go to regular testing, and I'm going to want field visits 2 times per month, and we can do that for 3 months and see how it goes. Probation, is there anything else that she needs? Yes. Is there anything else that you need from the court in order to be successful?
No, not that I can take over now.
All right. In this court, your attorney will tell you communication is key. When people are placed on deferred adjudication or probation, I want them to be successful. I don't want to have to send somebody to prison. Many of the people that you see over in the box, they were either on probation, didn't communicate, didn't report, or whatever they did not do. You understand? Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. We can go off the record. Here's the thing, meth and all of these drugs that people are doing on the street, you don't know what's in them.
These two hearings perfectly capture the difficult balancing act courts face every single day. In Barbara Shorey's case, the judge ultimately concluded that repeated probation violations, missed reporting, unfinished treatment, and lack of consistent progress outweighed the arguments for another chance. Even after hearing about trauma, family struggles, abuse, and CPS involvement, the court focused heavily on accountability and compliance, leading to a 6-year prison sentence after probation was revoked. Meanwhile, Brittany Cruz stood at a very different crossroads. Instead of revocation, the court chose structured supervision through deferred adjudication, but with intense conditions attached: drug treatment, community service, parenting classes, reporting requirements, and restrictions involving minors. The message from the court was unmistakable. This was an opportunity, not a free pass. And honestly, the contrast between these two hearings raises a major question for viewers. When should the justice system prioritize rehabilitation, and when does repeated noncompliance justify prison time? Some people will argue Barbara deserved more compassion given her personal circumstances. Others will say the court had already extended enough opportunities. If you found this courtroom breakdown as intense and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal drama every week.
Maybe the last time you use it, don't let that be you, okay?
Thank you.
All right, you're welcome.